In the name of God, the compassionate, the merciful, welcome, friends, to the 43rd episode of Crime and Punishment, a legal podcast, not a political one. We here at Crime and Punishment love Big Brother. We have zero political opinions. We do not believe in a left wing and right wing. We only believe in a united America and a united world. This is the official podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is augustusinvictus.com. You won't believe what is happening at the Southern Poverty Law Center, but workers at the Southern Poverty Law Center are protesting discriminatory working conditions. Staff at the historic Southern Poverty Law Center, a regal, noble tradition, a history of just angelic purity at the SPLC. Staff at the historic Southern Poverty Law Center say the civil rights organization is stalling contract negotiations and implementing a discriminatory office reopening plan. The crux of it, they're making the black people come back to work in person. But the people at the top, the white people, they can still work remotely. That's the SPLC for you, isn't it? Other stuff going on today. It's not all discrimination out there. We have some very good news as well. Let's see, LinkedIn has that one. Nope. All right, well, there it is. That LinkedIn link has it. Jackson makes SCOTUS history. And for the uninitiate, SCOTUS means the Supreme Court of the United States. That's their cute acronym. So you don't have to say Supreme Court of the United States or say Supreme Court and somebody asks you in reply, do you mean the Supreme Court of Michigan or the Supreme Court of Florida or the Supreme Court of the United States? So just say SCOTUS and everybody knows what you're talking about. In any event, the Senate voted Thursday, that is yesterday, to confirm Judge Ketanji Brown Jackson to the Supreme Court, making her the first black woman to be elevated to the nation's top judicial body. The federal appeals judge was confirmed to the High Court in a 53-47 vote, with 3 Republican senators, Susan Collins of Maine, Lisa Murkowski of Alaska, and surprisingly, Mitt Romney of Utah, can't believe he did this switcheroo, joining Democrats in supporting President Joe Biden's nominee. She will replace Justice Stephen Breyer, who is retiring at the end of this summer's session. A Harvard Law graduate, Jackson will be the first former public defender to serve on the Supreme Court. Her confirmation does not change the court's conservative supermajority of 6-3. Well, I've got to say, I am glad to hear that a public defender will be named to the Supreme Court of the United States. That warms the cockles of my heart. Oh, I'm sorry. There was a racial issue too. I didn't realize that. I didn't catch it. I guess she's the first black woman to be elevated to the United States Supreme Court. Really doesn't register for me because I'm a lawyer. And we want people who are qualified being judges. We want qualified people being put on the United States Supreme Court. Absolutely doesn't register with us what the person's race or sex is. Right? We want the most qualified person up there. The media, however, and the Biden administration, God bless him because we love Big Brother, their primary qualification for this job was that the person be a black female. But I don't care about that. I'm just glad that a public defender is finally on the Supreme Court. Things might start changing around here. Maybe this police state will begin to be dismantled. Who knows? She might agree with her fellow African-American Supreme Court Justice, Justice Thomas, that the government should be limited in its power, that this police state is out of control, and that the Constitution should have its day. I don't know. We'll see. It's still early in the game. She was just confirmed yesterday. So we'll see what happens with that. Just wanted to share the good news. Since things at the Southern Poverty Law Center are going so horribly, I thought we could use some uplifting news. Let's see. We are loud and clear on YouTube, says Seamus. Thank you for that. Good afternoon, everybody. I promised in these social media posts that we were going to talk about what? The rule of law. The bipolar nature of political rulings in America today. So, one of those, not guilty in first federal judge. Oh, I like this one. This is from the ABA Journal, the American Bar Association Journal. Federal judge complains prosecutors want more jail time for January 6th breach than for Kavanaugh protester. In brief, Kavanaugh, when he was being confirmed to the Supreme Court, had a lot of protesters. You might remember #MeToo. You might remember #BelieveWomen. You might remember a lot of people protesting Kavanaugh being appointed to the United States Supreme Court, not because he was a white male, but because he had allegedly engaged in, I don't know, inappropriate behavior in college by a woman who had been with countless guys because she was that kind of college party girl. In any event, there were people protesting Kavanaugh's appointment, or confirmation. There was a protester there. He was prosecuted when he got out of line. And the prosecutors today are going after the January 6th protesters in a completely different manner. And this federal judge had the sand to point out that there was a difference in these prosecutions. Let's read this one. Now, ABA Journal is a famously left-wing institution. Let's say the ABA is super left-wing. Some cynics might even call them Marxists. I wouldn't, of course. But just so you know where Deborah Weiss is coming from, this is a left-wing rag that you're about to read. So they're reporting on this ruling, but you can tell they're not happy about it. It is, relatively neutral. It's not like you're reading the New York Times or anything, but you can tell. A federal judge in Washington, D.C. complained last week that prosecutors seem to be seeking disproportionate sentences for nonviolent offenders who entered the U.S. Capitol on January 6, 2021. U.S. District Judge Trevor McFadden of the District of Columbia complained that prosecutors recommended more jail time for nonviolent January 6 defendants than for a protester who disrupted the confirmation hearing for then U.S. Supreme Court nominee Judge Brett Kavanaugh. The Washington Post has the story. Amazing that the ABA Journal would quote the Washington Post uncritically. I'm sure they're not politically aligned at all. McFadden spoke last Wednesday as he sentenced 37-year-old florist Jenny Cudd of Midland, Texas. A florist, by the way, being someone who arranges flowers. Super threatening profession. She might as well be an international arms trafficker, if you ask me. Sentenced this lady to 2 months of probation and a $5,000 fine. She has also paid $500 in restitution. Courthouse News Service and WUSA 9 also have stories on Cudd's sentencing. Well, they do hyperlink that. We will give them credit for that. Cudd had worn a bulletproof sweatshirt to the Capitol and had declared on a Facebook live stream, "Heck yes, I am proud of my actions." Of course, we censor everything on this family-friendly program, but she was clearly very emphatic about having been proud of being there at the Capitol that day. The federal government had sought a sentence of 75 days in jail. That's just over 2 months. It's 2.5 months, after Cudd agreed to plead guilty to entering and remaining in a restricted area or building. The government had recommended 10 days in prison for the Kavanaugh protester. Now, I don't think, I don't know. I doubt they said prison. They probably said jail. But let's say, whatever. 10 days for the Kavanaugh protester. 75 days for the Trump protester. Think about that. That's 7.5 times more incarceration time because of you are on the right wing. You're in the wrong party here. This is how the Soviet Union began, I would remind you all. Even though, all right, so let's start that sentence over again because it's so beautiful. The government had recommended 10 days in prison for the Kavanaugh protester, even though he had 14 prior arrests and accidentally knocked a chair into a bystander during his arrest, McFadden said. According to the Washington Post's tally, federal prosecutors have sought jail time for 12 of about 15 January 6 defendants sentenced on the charge to which Cud pleaded guilty. So to unpack that a little bit, there are, I don't even remember how many hundreds of defendants in this, but only 15 of them were charged with what Miss Cud was charged with, right? Of those 15, the prosecutors were seeking jail time for 12 of them, which means that the remaining 3 were probably offered probation. Now, why was Mrs. Cud up for jail time instead of probation? I imagine it had something to do with that bulletproof sweatshirt and her absolute lack of remorse. Heck yes, I am proud of my actions, if you'll recall those infamous words. The average sentence sought by prosecutors was a 2-month jail term. 8 of the defendants got a prison sentence, and in half the cases, the sentence was 30 days or less. Still, basically all of them, over the time that they were seeking for the Kavanaugh protester. Before the Capitol breach, McFadden said he couldn't remember seeing a nonviolent misdemeanor defendant sentenced to serious jail time, regardless of their race, gender, or political affiliation. Now, you might not think that 75 days is serious jail time, but apparently this judge does, which is a good sign, because 75 days is a lot of jail time for a law-abiding citizen. 10 days is a lot of jail time for someone who was just in the wrong place at the wrong time. Someone who's part of a protest. Someone who happens to be of the wrong political ideology. 30 days is a long time. 75 days is more than twice that. So he's saying he can't remember the last time there was a non-violent misdemeanor defendant looking at serious jail time. Thank God for this judge, because that seems like it should be common sense to everybody. Before the Capitol breach, McFadden said, excuse me, we already read that, but I did want to point out, if this guy, the Kavanaugh protester, had 14 prior arrests, and Judge McFadden is making this comment, then one can deduce, in the style of Sherlock Holmes, that at least one of those 14 prior arrests of this Kavanaugh protester was a violent crime. Otherwise, he wouldn't say that, because it appears that that was a misdemeanor as well, so he must have been a violent offender. McFadden said it feels like the government has had 2 different standards, quote, and I can't abide by that, end quote. Assistant U.S. Attorney Laura Hill had argued that January 6th was unlike anything in American history, and there was a vast amount of violence and destruction. In response to arguments by Cud's lawyer, Hill said the Kavanaugh protesters were escorted out of the Capitol, nobody had to evacuate the building, and the hearing was able to continue. Now, about this vast amount of violence and destruction, I was reading another article. It's probably in one of the ones we're going to read in a minute here, talking about the deaths of the police officers. And these police officers died by suicide after the January 6th riots. Does that not give anybody else pause to think? Why did they do that? Why did the guy in charge of Waco under the Clinton administration, why did he kill himself? And I'm not asking that flippantly. There's evidence that he killed himself because he knew what happened at Waco. He was responsible, and he actually had a conscience, and he killed himself when he found out what had happened. We can only speculate why these police officers at the Capitol would kill themselves. But do you think that it's because it was, like another police officer said who testified before Congress, that it was like being back in Fallujah, like it was a medieval battle on the Capitol grounds? Do you think that this medieval battle, Fallujah-like medieval battle, was so horrific that these police officers couldn't stand the sight of it in their memory anymore and had to commit suicide? I sincerely doubt that. That is just insulting. One has to wonder, and why are there no news articles about that? They love parroting that line, that police officers died and by suicide after the event. They don't talk about why. Just like they used to talk about the deadly Charlottesville riots where 3 police died, not mentioning the fact that actually they crashed their own helicopter and died after the event. You got to wonder why they keep saying these cops committed suicide afterward, but they don't talk about why. None of these guys left a note. None of their families wanted to talk about these evil white supremacists who were responsible for the death of their husbands. Come on. It doesn't fit the narrative to say why. Now, I had a plan to talk about 2 opposing cases. This is from the New York Times. I am not getting a subscription to the New York Times. Let's just read the headline, right? Because we're not going to read this. But let's talk first about Bannon. Bannon, as you may know, is facing criminal charges for resisting a subpoena. He was subpoenaed to testify, apparently before Congress. I'm admittedly not expert on the details here, but he was apparently subpoenaed, refused to submit to the subpoena, didn't show up. Now he's facing criminal charges. His defense is, well, I talked to my lawyers. They said not to turn myself in, or not to submit to the subpoena. They said it was illegal. They said that there was executive privilege, and that I was not required to appear because of executive privilege. And I had a good faith basis for that because other people were claiming executive privilege, and I should not be held criminally liable for when I relied in good faith upon my attorney's advice. That's a viable defense. However, the judge in charge of his case felt otherwise. He said, no, you're not allowed to use that defense. It's interesting because this judge was famously one of the people who argued against the subpoena power of Congress and was claiming, because of George W. Bush administration's aides, that executive privilege applied. What a world. What a world. I'm going to share with you a story that I heard in law school that I believe is true about Justice Scalia. May he rest in peace. Justice Scalia, everybody knows, was a fierce defender, of the executive branch. One looking in from the outside might think he had a problem with Congress. As a matter of fact, he gave so much deference to the president, it almost seemed like he had a bone to pick with Congress. Well, the story I was told was this. He used to be a Justice Department attorney, and one day he went in to argue a case, and a bunch of congressmen just ripped him up as a young attorney. Just absolutely abused him. And that was the moment where he became anti-Congress, and pro-executive. So, this is an interesting turn of affairs where a government attorney would have that same view that no, these aides can claim executive privilege and Congress can't subpoena them, etc. Then when he becomes a judge, he does a 180 and says, no, you can't use that defense that I used when I was working for the government. Just an interesting turn of events. I'm not expert on that case, so I can't comment on it in detail. I can't make any judgments on the judge's ruling. I can only point out how interesting it is. But the fact that you can't rely on your attorney's advice, there's got to be a really good reason for that, right? Because from the outside looking in, and again, I don't know all the details, but from the outside looking in, it seems as though it was a political ruling. There are so many judges being quoted by the mainstream media right now, and the journalists are just gloating. You remember we read an article just a couple weeks ago that this phrase that was quoted by the media was courtesy of this heroic judge who said all these horrible things about right-wingers, or should I say great things about right-wingers. Courtesy of, they're just gloating about all these opinions coming down from coast to coast against the Capitol riots, the January 6th white supremacist insurrection. Media's having a field day. It's like you can't have a ruling on any of these cases involving January 6th without it being interpreted, at least, as political. So here's the really awesome one. This is in the New York Times. Judge finds man not guilty in first January 6th acquittal. How about that? You know, it's not up on my computer, but I think it's worth taking the time to see if I still have it up on my phone, because it's such a good article. But basically, the defendant, Matthew Martin, had claimed the police let him into the Capitol during last year's pro-Trump riot. The judge agreed. How about that? We have been hearing this whole time, the police let us in. There were federal agents inside of these groups that were pushing people to go in. It was a setup by the FBI. They were doing the whole thing. The police waved us in. They let us in. And we've been told by the media this entire time, since January of last year, oh, that's a conspiracy theory. These people are just trying to shift the blame. The feds would never do that. The police would never do that. They wouldn't let them in. These people are white supremacist insurrectionists. They stormed the Capitol. They struck at the very heart of democracy. And yet, when the facts come to light, when a man gets a trial, a fair trial, look at that. The judge agreed. Let's read instead from The Hill, because the New York Times, you can't trust fake news. Not a political statement, just a statement of fact. So The Hill, they try to actually be neutral because they're reporting on things going on in D.C. They can't be one way or another, or it'll be really easily found out. They at least aim for it. Judge issues first acquittal to January 6th riot defendant. Interesting that this is under the national security heading. Washington. A federal judge on Wednesday acquitted a New Mexico man of misdemeanor charges that he illegally entered the U.S. Capitol and engaged in disorderly conduct after he walked into the building during last year's riot. U.S. District Judge Trevor McFadden issued the verdict from the bench after hearing the testimony without a jury in the case against Matthew Martin. Now, without a jury means this was a bench trial. This man gave up his constitutional right to a trial by jury and asked the judge to hear it alone. Usually the judge does not find facts. The judge only conducts the trial. He makes determinations of legal issues, but he doesn't determine whether these things are true or not. In this case, he was the fact finder. That's a rarity. I don't know why they decided to do that, but they did that, and look at that. It worked out for him. McFadden, who was nominated by former President Trump, acquitted Martin of all 4 counts for which he was charged. McFadden said it was reasonable for Martin to believe that outnumbered police officers allowed him and others to enter the Capitol through the rotunda doors on January 6, 2021. The judge also said Martin's actions were about, quote, about as minimal and non-serious, end quote, as anyone who was at the Capitol that day. Martin is the 3rd Capitol riot defendant whose case has been resolved by a trial. He is the first of the 3 to be acquitted of all charges that he faced. The first 2 Capitol riot trials ended with convictions, although McFadden acquitted one of those defendants of a disorderly conduct charge after a bench trial last month. In the same courthouse where Martin was acquitted, a 4th trial continued on Wednesday for a former Virginia police officer who is charged with storming the Capitol with another off-duty officer. Jurors heard testimony from the fellow officer who pleaded guilty to a riot-related charge and agreed to be a witness for prosecutors. Martin, whose bench trial started Tuesday, testified that a police officer waved him into the building after the riot erupted. A prosecutor dismissed that testimony as nonsense. Of course, the prosecutor dismissed that as nonsense. They've been dismissing it as nonsense for the past year and 3 months. The media has been dismissing it as nonsense this entire time, despite the fact that there are cameras and countless witnesses to the fact that the police let the people into the building. Finally, a trial has come and the facts have come to light. So check this out. The judge, however, said video shows 2 police officers standing near the rotunda doors and allowing people to enter as Martin approached. One of the officers appeared to lean back before Martin placed a hand on the officer's shoulder as a possible sign of gratitude, the judge said. McFadden described Martin's testimony as largely credible. The judge said it was not unreasonable for him to believe that officers allowed him to enter the Capitol, even though alarms were blaring and broken glass was strewn about the floor. Martin was charged with 4 misdemeanor counts: entering and remaining in a restricted building, disorderly and disruptive conduct in a restricted building, violent entry and disorderly conduct in a Capitol building, and parading, demonstrating, or picketing in a Capitol building. The judge said Martin appeared to be a silent observer of the actions of others. McFadden didn't find any evidence that Martin intended to disrupt Congress from certifying President Joe Biden's electoral victory. Dozens of Capitol riot defendants have pleaded guilty and been sentenced, but Martin is the first to testify at trial. You might remember that case we talked about a few weeks ago. The first guy to go to trial, Guy Reffitt. His son, Jackson Reffitt, just hero of the Socialist Republic, went to the FBI, turning in his father, then wore a wire for the FBI to set up his father, then testified at his father's trial. This freaking kid. Guy Reffitt did not take the stand. He did not speak in his own defense. Now, you don't have to. You certainly don't have to. You have the right to remain silent. You do not have to testify if you think it's going to be used against you, but, and it's a case-by-case basis, do not take this as legal advice. This is not legal advice. This is just commentary on these cases and my general experience. If there is a jury, if you're on the jury, or if you're in any situation where somebody accuses another person of doing something, and that other person doesn't even bother to defend themselves, what do you think of that? If Bobby runs in the room and says, "Mary just tried to stab me with a knife," and Mary says, "Nothing. I am exercising my right against self-incrimination," what do you think about that? You think Mary stabbed the guy. Otherwise, she'd be telling her side of the story. If my son came in here saying, Cesare kicked me in the stomach, and Cesare comes in and doesn't say anything, I'm going to assume Cesare kicked Beowulf in the stomach, right? If he doesn't come in saying, no, Beowulf hit me first, then I'm going to assume that Beowulf is right? That's human nature. The legal system that we have set up with all these protections, it doesn't register with human nature. These are legal things. That's why you were supposed to have juries of educated people, right? People who were responsible members of society. It wasn't this mass democratic movement where anybody can be a juror. It was a totally different system in its inception. You're supposed to use logic. But in today's jury system, it's just a sad fact that people hear the state's case and they're thinking the entire time, I wonder what this guy is going to say about this. What does he have to say for himself? And then he says nothing for himself, well, the jury thinks, well, he's hiding something. They don't think, well, he has the constitutional right not to say anything, and that prosecutor is going to twist his words into something he didn't say. I don't blame the guy for not testifying. They just don't say that. That's what it's become. Why is the outline up? Oh, you know what? Because I never gave you all the links to the newsletter and whatever the other thing is, the viral style. Anyway, Ukrainian officials are blaming Russia for war crimes. They're trying to remove Russia from the UN Human Rights Council. And last I heard, the U.S., correct me if I'm wrong, people in the chat, but the U.S. was trying to suspend Russia from the Security Council because of accusations of war crimes. That would be huge. But seeing that reminds me that we need to get into this book here, Advanced Barbarism. For those who were here for the last class, we talked about this book. We read through the chapter called Downfall, chapter 7 about the inception of the Nuremberg trials. We're going to start where we left off. But first, a word from our sponsors. I'm going to post the newsletter that went out just earlier today. There it is. And I'm going to post, the viral style, which you would already have if you were subscribed to the newsletter. So do us both a favor. Subscribe to the newsletter. And then if I forget to put these things in the chat, then you already have it. How about that? Whitmer court decision just dropped. 2 found not guilty and mistrial on all the others. No way. No way. That news is from Utah Strong in the chat. I did not know that. You heard it here first, everybody, from Utah Strong. 2 not guilty, mistrial on all the others. How about that? This is the kidnapping case in Michigan where the FBI set up this plot to kidnap the Michigan governor, which was never going to happen, which was completely manufactured by the FBI. One of those FBI agents, not gloating, but he was arrested for domestic violence charges. Just a bunch of corrupt, just disgusting people in the FBI. Good. In the words of Jocko Willink, good. I'm glad they were found not guilty. Those mistrials have got to hurt. Now, the problem with mistrials is the state comes back and they usually get the conviction the second time, almost always, because now they know your defense. Now they know everything and they're going to prepare against that, make up more lies, bring in more witnesses to tell things that are just not true. Alex says the regime punishes dissidents worse than people who pathologically comply with the demands and narrative of the regime. Yeah. That reminds me of another article that I posted earlier this week, which reminds me also, look in the description. All the links to the social media are down there. Also in the newsletter, I publish all the links to the social media. So on Twitter, Facebook, Gab, LinkedIn, Telegram, I post these things. One was an article by LifeSite News, I believe. No, it wasn't. It was a leftist article. I think it was NPR. Yeah, because they were attacking these women amazingly. The allegation is this. This shipping company, I think the shipping is part of the company. It's not a shipping company. It's like an energy company. And they use waste for the energy. I don't know if they burn it. I would imagine they burn it. I don't know. I'm not a chemist. But they use waste, medical waste, apparently as well, to provide energy, right? These women who were part of an anti-abortion group told the driver, hey, what's actually in those boxes are dead children. We want to take those off your hands. Don't give them to your company because they're just going to burn them. So the allegation is this. This company is literally purchasing dead children to run their energy program. It's so outrageous that it can't possibly be true. So obviously these women are conspiracy theorists. But they claim that this driver, he said, well, what's in the boxes? He was suspicious. Why do you want these boxes? Because they're trying to buy them off him. And they told him. And he had a moral problem with what he was doing. And he said, well, what are you going to do with them? And they said, we're going to give them proper burials. So he gave it to them. He gave them these dead children so that they could bury them. That is the anti-abortion activists' statement. They're charged with a crime now. They really were dead children. They really were taking those dead children to bury them. That is undisputed. The only thing in dispute now, it appears to me, is did the driver know that, or did these people just straight up steal these dead children and give them proper burials? Now, of course, they're not charged with a crime for burying dead bodies. Heavens, no. They're charged with the theft, right? And amazingly, NPR pointed this out. You know what? I should just go to the... we're not going to be able to read the book today, guys. I'm sorry. Well, this is too important. This is actually super important. And I'm going to quote the Liberal article rather than anything that would be anti-abortion or in favor of these people, right? Because we want it from the most uncharitable source possible so that we know what everyone agrees on. And what everyone agrees on is, number one, these really were dead children. Number two, these people really were taking these dead children to bury them, to give them proper burials. And here's another part. That the federal government has a statute against this very thing. They have a statute protecting the trafficking of aborted children. The NPR headline is, an anti-abortion group claims it took 115 fetuses from a medical waste truck. An anti-abortion group that is facing previous federal charges said it took 115 fetuses from a medical waste company and buried 110 of them at an undisclosed location. Washington, D.C. police, which originally said it found 5 fetuses in one of the group members' apartments, is continuing to investigate the case. How insane is that? It opens with Washington, D.C. police find 5 dead fetuses in a woman's apartment. That's macabre. That's just wild. But why would she have to have them in her apartment at all to give them a proper burial? That should really be where everybody's outrage is. Why are these children being trafficked to a waste management and energy company? Why is that not the outrageous thing? The outrageous thing is these women were stealing these dead fetuses to bury them. That's what's wrong here, according to NPR. At a news conference Tuesday, two members of Progressive Anti-Abortion Uprising, Teresa Bukovinec, that's how we're pronouncing it, and Lauren Handy, said they got the fetal remains from a medical waste company employee who gave them the box from his truck. The two women saw the medical waste truck from Curtis Bay Medical Waste Services outside Washington's Surgic Clinic, which performs medical procedures such as abortions. Medical procedures. So when they give a lethal injection to an inmate at his execution, do we euphemistically call that a medical procedure? When Jeffrey Dahmer deliberately peels the skin off of one of his victims after beheading them, is that a medical procedure? Because he's using the tools and it has something to do with the body and you're just dissecting like you would in a lab. That's a medical procedure? Besides, it's good cooking, right? In total, they claim there were 115 fetuses in the boxes. Bukovinec said in the news conference that she asked the driver of the truck if he would get in trouble if they took one of the boxes. She says he was shaken when they told him what the contents of the box were. The two women apparently told the driver they would bury the fetuses. The driver thought for a second, and he said, "Okay," Bukovinec said. Curtis Bay Medical Waste Services told WUSA 9 that it does not transport fetal remains, and denied that any package was handed over to the anti-abortion group. The Baltimore-based company did not respond to NPR's request for comment. Several members of the anti-abortion group faced federal charges from 2020 when they protested at an abortion clinic. They were charged with conspiracy against rights and violating the Freedom of Access to Clinic Entrances Act. Curtis Bay Medical Waste Services is telling the news, No. We don't transport fetal remains. And we certainly didn't hand over any package to this anti-abortion group of lunatics. How many Hollywood movies have that same exact plot? Right? That there's some larger-than-life, beyond accountability corporation that's trafficking in human beings, clones, body parts, some other grotesque thing, and they have this clean image, and nobody knows the evil going on behind the scenes until one day somebody escapes and tells the whole story and they bring the whole place down. How many Hollywood movies are there like that? Like thousands. That's a lot of what it sounds like, doesn't it? The plot of one of those movies. Curtis Bay Medical Waste Services says, "We don't transport fetal remains, and we certainly didn't hand over any package to these people. They're crazy." Anyway, that's what's going on there. We've got about 10 minutes. PADFA. What's up, PADFA? Link to advance to barbarism. Wait, you found a link? I don't have a link. If that's what you mean. This book, I've got like an original 1953 copy. I got it in law school. I couldn't tell you where I got it. White House press secretary, this is not Jeffrey Epstein. White House press secretary is negotiating leaving her job to work for/with the very people asking her questions every day. You don't say. They couldn't do that. Like the government would be in bed with the media. Pull the other one. First it's fossil fuels, now it's fetus fuel. Yeah, that's crazy. Right. Just what an insane allegation. You know, I think I have another article on this, actually. This time on my phone again. No, I don't. But that was the crazy allegation that these people are using these aborted fetuses for their energy program. Wish I had that one. But let's talk about advanced barbarism. So last time we talked about the inception at the Tehran conference of the Nuremberg trials. These sham trials to try the quote-unquote war criminals in the Nazi regime. And of course they were not allowed to challenge the jurisdiction thereof, this kangaroo court. So, they came to agreement. 18 months were to pass before the compromise agreed upon at Tehran could be put into effect. But in due course, the law officers of the Crown, that is Britain, this, by the way, if you weren't here last week, this is written by a British lawyer. The law officers of the Crown received instructions to consult with the American, Russian, and French legal authorities in order that the plan might be prepared for the trial of the German leaders after unconditional surrender had taken place. For learned and experienced lawyers, the task was both invidious and thankless. First of all, we commented last week, unconditional surrender means there's no treaty. You just give up, and you let us do whatever we're going to do. In civilized warfare, two countries meet, and one loses, and they're holding out, and they come to an agreement. All right, we're going to stop fighting. We will see this. You will see that. We're not giving this up. So on and so forth. You negotiate the settlement. There was no such negotiation at the close of World War II. Everyone had to submit unconditionally. Germany, Japan, anybody who fought against us, you have to just lay down and die and pray to God that we are merciful to you. So that's the most interesting thing. It had to be unconditional surrender. Because what kind of sane person, political leader, whether civilian leader or military leader, is going to say, oh yes, we agree to be tried by your tribunals. You powers who have allied together, Britain, France, America, the Soviet Union, yes, we will allow our leaders, our lawyers, our military personnel and officers to be tried by your lawyers. That's exactly what, nobody would agree to that. That's why it had to be unconditional surrender. For learned and experienced lawyers, the task was both invidious and thankless. It was invidious because it entailed setting at naught the principles in which they had been trained during their whole lifetime. It was obvious that only a small proportion of the prisoners were war criminals, according to the accepted definition of the term. The only way out of the difficulty was to create new offenses, and then to assert that anyone who had in the past committed these offenses should be deemed a war criminal. Retrospective legislation has always been abhorrent to lawyers, and it must, in consequence, have been particularly distasteful to the learned law officers of the Crown to frame charges alleging that criminal acts had been committed before these acts had been declared crimes. We have a phrase for that in the Constitution. It is called an ex post facto law, after the fact law. If you, for instance, were growing, wheat's a bad example because that actually is outlawed now. I don't know, green beans. Green beans are legal, right? I think if I were to grow on my, let's say, I don't know, mushrooms, not hallucinogenic mushrooms, but just regular old mushrooms, right? I've got them growing in my closet. There's no local law against it. There's no federal law against it. I'm just growing some portobello mushrooms in my closet because I love cooking them. No laws whatsoever, state, local, federal. The year is 2021. I grow these things all year. 2023, next year. DeSantis says, all right, Floridians, these portobello mushrooms are an invasive species. We can't have them in our grocery stores. We can't have them anywhere. Can't have them in our schools. Certainly can't have them in our closets. So anyone found with portobello mushrooms is guilty of a felony in the third degree. This law goes into effect January 1st, 2023. You can't take that law and go back and charge someone with it for growing mushrooms in their closet in 2021. Is that not common sense? That's law 101. That should be just critical thinking 101. That should be common sense 101. You do something in 2021, 100% legal. 2023 comes along, somebody makes a law against it, and now they want to prosecute you for you doing that back in 2021. You cannot do that. There's a constitutional guarantee here in this country. That is an ex post facto law. Now, they might not have written constitutions with these things in Europe. Maybe in Germany they didn't have that written down. I don't know. I don't speak German. Even if they had a constitution, I couldn't tell you. But I can tell you this. The chief prosecutor at the Nuremberg trials was a United States Supreme Court Justice, Justice Jackson. Justice Jackson knows full bloody well what an ex post facto law is. He knows if these things were not crimes from 1939 to 1945, now we're making these trials in 1948 and we're just making up new laws to prosecute, they cannot apply to the period of 1939 to 1945. It's just a basic Platonian concept of justice. This is the court that we created. These are the Nuremberg trials. That's why this attorney, Mr. Veal, says retrospective legislation has always been abhorrent to lawyers, and it must in consequence have been particularly distasteful to the learned law officers of the Crown to frame charges alleging that criminal acts had been committed before these acts had been declared crimes. Even more distasteful must have been the necessity of giving effect to the decision of the politicians that at the coming trials, quote, the tribunal should not be bound by technical rules of evidence, end quote, but could admit, quote, any evidence which it deemed to have probative value, end quote. That is to say, might help to support a conviction. Yes. Distasteful indeed. We have been developing these rules of evidence for centuries, if not millennia. There are reasons that you've probably heard the word hearsay. You've probably heard about, you have the right not to testify against yourself at trial, right? However, there are things that are not hearsay, and saying something against your own admission or against your own interest is one of those things if you are the defendant. So, for instance, if I'm on trial for war crimes, one of those war crimes is looting, and they bring in a witness who says, I saw Invictus looting the Foot Locker during this mostly peaceful protest. And he said, as he was running out with his Jordans, I just looted some Jordans. That's not hearsay. That's an admission by the person on trial. That's acceptable. But there are other statements that are hearsay because they are offered to prove the truth of the matter. So if someone else said, hey, Invictus is stealing those Jordans, maybe that could be an excited utterance. Maybe it could be a hearsay exception. But let's say it didn't happen in the spur of the moment. Somebody off the street just came up to you and said, I saw Invictus and he was carrying those Jordans out of the store. Well, you couldn't testify to that statement, right? That's the sort of thing that we've been developing these past several centuries in the rules of evidence, because it's just not fair. It's not fair by any stretch of the imagination to say, yeah, I saw this guy and he said that this happened, but you can't talk to that guy, right? Just like the right to face your accuser. That is a fundamental civil right in this country. Really, in all of Western civilization. You can't have someone say, Invictus did X, Y, and Z, and then they don't show up for the trial, and you just convict them on what that person said. That would be 100% illegal, and every attorney knows that. If you don't know that, you should not be an attorney, right? What he's saying is, we don't need to be bound by, and this is a direct quote, the tribunal should not be bound by technical rules of evidence, but could admit any evidence which it deemed to have probative value. Maybe that's how the Americans hired a Hollywood team to compile a video and produced it as evidence. A video of these war crimes of the Holocaust by this film crew. That would never fly in an American courtroom. Granted, the Germans were not American citizens. They're not entitled to the same rights as an American citizen. The Constitution doesn't apply to them. But concepts of justice do. I put in the newsletter, if you're here because of the newsletter, you're probably waiting for this. So we're going to skip ahead to this one part, because this was super relevant to me. When I was in jail, I read a book called Wolf Hall. And it was about Thomas Cromwell. Thomas Cromwell was a super tough guy. Rose from nothing to become the lawyer for King Henry VIII. When King Henry VIII started just executing everybody, broke from the Catholic Church, made the Church of England. It was obviously an unprecedented scandal. Thomas Cromwell was the legal guy that was greenlighting all this, that was issuing all the orders, issuing all the warrants, setting up all the trials, and, as you heard earlier, framing the charges. Now, this British lawyer talks about they framed charges alleging that criminal acts had been committed. Now, that's not necessarily a negative turn of phrase, to frame charges. That doesn't mean you're framed, but that is where it comes from. When you say, I was framed, I was set up, what you mean by framed is they framed the charges against you. They constructed the charges. Think of it like a house frame, right? They built these charges up. They made a case. They built a case against you. That's what framing charges means. Well, this guy, Thomas Cromwell, was the guy who would do that for King Henry VIII. As you can imagine, King Henry VIII, like his daughter Elizabeth, had a lot of enemies. This British guy, I don't know, maybe he was Catholic, but he does not have a high opinion of King Henry VIII. That is my alarm. They should receive their just punishment. All right, so here we go. For months, the eminent lawyers instructed to prepare for the trial of the German leaders struggled with their task, which, as we have remarked, was not only invidious to them as lawyers, but entirely thankless, since in the eyes of the man in the street, the task presented no difficulties whatsoever. Yeah, think about it. The average American seeing what's going on in the news right now, if Ukraine just out of the blue just wiped out Russian forces and were the clear victors, and then we put the Russians on trial with some international court, all these average Americans watching CNN and Fox News, they're going to think, well, easy day. Just get in there and prosecute them. We got all these pictures. We've been seeing them up all over CNN and Fox News. Everybody's playing them. Mass graves, war crimes. You've been saying it for months now. You got all the evidence in the world. There should be no problem. Piece of pie. Same thing after World War II. The average person believes, well, there's no difficulties presented whatsoever. These Nazis were obviously war criminals. Crucify them. And let their blood be on our hands. The guilt of the German leaders could not be in question because the press and the radio unanimously asserted it. My God, is he talking about the Russia-Ukraine war, or is he talking about World War II? That the persons whom it was proposed to try were criminals, even before the charges against them had been decided, was as clear to the man in the street as it was to Dr. Garbett, the Archbishop of York, who on March 20th, 1945, in an outburst of enthusiasm, explained to the House of Lords, "It is for the sake of justice, for the vindication of that underlying sense of the difference between right and wrong, which makes us demand that these criminals should receive their punishment. Now, before this week, when all the news started coming out about mass graves, when, we didn't see a video of a guy on a bicycle being shot, and see that newsreel played over and over and over and over. Before that, what war crimes exactly were we talking about? But you knew that the Russians had committed war crimes, right? I mean, the news said it. Everybody is in unanimous agreement. No one questions that the Russians were war criminals. But what crimes exactly did they commit? Did anybody ever stop to think about that? Now, there are specific allegations come out. Now, the Ukrainians are alleging that they're finding mass graves of civilians left behind after a Russian retreat, which is interesting. The Russians are retreating, killing all these civilians, but they've got the time to bury them all. Like nobody's going to find them, right? Like, oh, we're going to dig these graves and put all these bodies in here and we'll cover up our crimes. Come on. You got to be plain gullible to think that retreating Russians are just murdering massive amounts of civilians, taking the time to dig their graves to cover it up. That's insane. But people believed it about the Nazis, right? That Katyn massacre, those Nazis, they massacred all those Polish people, dug a mass grave, left them there. Let's try them for that. Turned out it was the Soviets. Maybe this entire thing is one grand instance of karma, right? That the Russians did this to the Germans and now it is being done to them. Which leaves open the question, when's it coming back on America? But let's get to Thomas Cromwell. What need was there in such circumstances for complicated arrangements and technicalities? What better precedent could be adopted, slightly adapted perhaps, to comply with present-day susceptibilities, than that provided in 1539 by the great Englishman King Henry VIII, equally distinguished as a pious defender of the faith and as a tireless wielder of the sword of justice? Clearly, that is sarcastic, and that's what makes me think he might be Catholic. Did I say Catholic? I mean, clearly that is sarcastic, and he might be Catholic because obviously King Henry was the opposite of a defender of the faith, and he did not ever wield the sword of justice. Having detained the aged Richard Whiting, abbot of Glastonbury, in the Tower, that is the prison, right, where they keep all their political prisoners. After having detained him, the abbot of Glastonbury, in the Tower for many months without preferring any charge against him, Henry at length decided it was time that the criminal should receive his punishment, for which purpose he should be returned to his native Somerset. Oh, that's nice. It sounds like King Henry VIII is going to exile him to Somerset. Great. I think most people would take that as their just punishment for whatever offense it was, as abbot of Glastonbury probably saying, no, the Catholic Church is not under your direction. That's the death penalty. But it sounds like he's being sent to Somerset for some holiday, right? The order to His Majesty's judges has been preserved. It is in the handwriting of Henry's chief minister, Thomas Cromwell, and reads, quote, "The abbot of Glaston to be tried at Glaston, and also executed there with his complices. See the evidence be well sorted and the indictments well drawn." End quote. In other words, the conclusion here is a foregone one. He will be executed, as will everybody who helped him, right? But we've got to give him a trial. So, see the evidence be well sorted and the indictments well drawn. In other words, frame these charges so that there is no escape and make sure that the evidence is well sorted out. Thomas Cromwell was a brilliant guy. Absolutely an amazing lawyer. Nobody denies that. But ruthless. Absolutely without any moral compass. All about power. It must be acknowledged that this direction, that is the direction by Thomas Cromwell, take this guy to Glaston, put him on trial, and execute him. It must be acknowledged that this direction is a model of brevity and lucidity. The stupidest judge could have been in no doubt as to what was required of him. A slight but unmistakable note of menace may be detected in the last sentence, and we may be sure that the evidence was well sorted, and that there was no slipshod work in the drawing of the indictments. In fact, no hitch of any kind delayed the fulfillment of the royal wishes. Very shortly afterwards, on a grey November morning, the underlying sense of the difference between right and wrong was vindicated by the hanging and quartering of Abbot Whiting and his accomplices. So, same thing at Nuremberg. We're going to give these guys a trial, and then they're going to be executed. And like Stalin said, whatever. Try them however you want, as long as they're executed. That was the whole purpose. And that's why he's invoking this instance of King Henry VIII murdering the executing after a fair trial, the abbot of Glastonbury, because that was the actual legal precedent. Because there was no real legal precedent for these international military tribunals, or for the terrible things that happened there. But we will continue on. We are over time, and something is clearly wrong with my health. So we will end there. We will pick up next week. I will try to do less news next week and more of this book. So till then, everybody.